Thank you. Sir James, Mr Hussain, before we start, we've received another communication from an outside party. Some of us have read it, some of us have literally glanced at the author. As before, we intend to completely ignore the document for the purposes of this hearing. Thank you.
Thank you, my lady. My ladies, my lords, ground one then.
And before we do that, forgive me, Mr Hussain, because I know we are very keen to hear from you on ground one and ground two. Question of reporting restrictions
Yes.
has come again. We've received a note. Can we remember that in the course of this discussion we are being live streamed?
Yes.
So can we be very careful what we say?
Yes.
Sir James, look, this has come in 9:45 or 10 o'clock. We've had a quick look at it. Our instinct is that we would wish to take a position on reporting restrictions that, broadly speaking, mirrors the Minister's statement on the 20th of June, where she said the attacks at Elbit Systems and Intro Precision remain sub judice to avoid prejudicing future criminal trials. She would not comment on the specifics of these incidents. So we are looking for some sort of restriction that avoids commenting on specifics of any of those two incidents, or but not going any wider. So what we are asking you to do is to have a think about what could be produced that might meet that narrower position, to engage with the press, who have to be put on notice of what is now being sought, and for us to deal with this as an appropriate moment. We don't want to delay Mr Hussain's submissions, nor do we want to act with undue haste. It's a bit fiddly. But our instinct is that when we look at the order that Mr Justice Chamberlain gave, 1C is too wide, and we don't understand why that's there. But the specifics of the instance, we do think probably need to be protected in terms of reporting restrictions.
My lady, can we take that away? Of course, I hear what the court has said. But that will require us, I think, to have another discussion or a first discussion with counsel for the Crown.
Yes.
In the ongoing cases.
Yes.
So
yes.
that may not happen.
Can I just
today.
check with my lord?
Yeah.
And
Thank
maybe
you.
that's something that Mr Blundell can pick up tomorrow morning.
Indeed, but understandably, we would like to resolve this during the course of the day if we can, and you do need to put the press on notice of effectively what's being suggested, which is a discharge of paragraph 1 of Mr Justice Chamberlain's order with a varied formulation. I mean, the fact is now we have a full judgment which is in open from the Divisional Court, which refers to these two incidents and so on and so forth. Yep.
But yes, I'll just have to take that back to the CPS lot because I don't want to.
Thank you very much. Thank you, Mr Hussain. Ground one.
Ground one. My ladies, just one word about timing.
Yes.
We were supposed to be 2:30. I think Sir James went over by 10 minutes.
He did.
And we're slightly late.
Yep.
So can I have until around 2:45?
Well, I think let's sit into lunch if we have to. We do need
Okay.
to.
Sure, of course.
We'll see how we go.
My lady, ground one then. Important.
We have a new skeleton argument, do we?
Sorry. Can I explain what that is? When it comes to fair balance, I'm going to, in the interest of time, just refer to our skeleton. It's not new, save in the sense that it gives you, I think in pink, in red, E references, bundle references. That's all it is, so that I can just not have to spend all the time giving you all those references.
Thank you very much.
Not at all. My lady, so ground one, a narrow point, an important point, we say, headline submission. The Divisional Court was correct to construe the policy as requiring the Secretary of State to identify a particular need, Div Court at 91, for the proscription of an organisation over and above its meeting the statutory threshold. That's the construction issue. And 2, it was entitled to find that the Secretary of State had failed to do so in this case. On that second question, there's no appeal, and Sir James, I hope it's fair to say, just gave you what he frankly described as a jury point. So I'm not going to spend time on that second question. And my focus of my submissions will be on the construction point. I have 5 points by way of positive case and 5 points by way of response. Positive case, first point. The court, they're short points, you'll be pleased to know. The court observed correctly at 83 that a decision to prescribe requires the Secretary of State to consider 2 distinct questions. First, she must ask whether she believes the organisation to be concerned in terrorism. That's our first question in our skeleton. It's a definitional question. It's a condition precedent to the exercise of the statutory power. But second, the Secretary of State must ask herself whether there's a particular need to prescribe. The second question, a normative question, since, as Sir James himself accepts in his skeleton, 47C, quote, not all organisations which meet the concerned in terrorism requirement would necessarily be prescribed. The fact that there are 2 stages is very clear from the policy itself. Please can I take you to that? That's supplementary 1, tab 24, hard 308, soft 317. The policy is actually the previous page, but the bit that we were looking at yesterday, 308, proscription criteria, heading, what is a prescribed organisation? I asked Sir James to read this because in the final clause of the first sentence, you have an addition. Under the Terrorism Act, the Home Secretary may prescribe an organisation if they believe it's concerned in terrorism. It should be full stop there. But
Sorry, Mr. Hussain. Your bundle references are wrong on the electronic bundle.
I said 317E. 317.
317.
Yes.
Yeah. Maybe you. Sorry. Okay.
I'm so sorry, Martin.
I checked a number of your references given yesterday when you were going through quite quickly, and they weren't right. So can we just keep an eye on them? 317 is a good reference.
That's very frustrating to hear. I'm very sorry.
That's okay.
Could we seek to correct if you
Don't worry. I've got 317 and I can find them.
I'm very sorry, my lord. That's very frustrating. So 317 in soft, heading prescription criteria. What's a prescribed organisation? Under the Terrorism Act, Home Secretary may prescribe an organisation if they believe it's concerned in terrorism. It should stop there. That's the test in section 3.4, you'll recall. But what the policy adds is this, and it is proportionate to do so. And then that question is answered at the bottom of the page. If the statutory test is met, then, the Home Secretary will consider whether to exercise discretion. In considering whether to exercise discretion, the Home Secretary will take into account other factors, including. Now, I think Lord Justice Lewis said that this is an odd animal. It's a public document. It was something that was presented in substance, that's the phraseology used, in substance presented to Parliament in both annexes to both the March and June Min sub. And we say that the effect is clear that there are 2 stages. The second point I want to make concerns that second stage. And really, this is the fulcrum point for this ground. We say that the court below was right to find at paragraphs 83, 84, and 91 that the purpose of the policy is to constrain the use of discretion, para 83, 84, it's an additional qualitative threshold. Paragraph 91, the purpose is to limit the use of the discretionary power to proscribe. And that is where we join issue, fundamentally, with Sir James. He says that this is just transparency promoting, if you like.
Don't worry. Thank you.
He says it's transparency promoting. We say it's on a proper objective construction. It's constraining, not a straitjacket. I don't know how many times that term was used. It's not a straitjacket because it's a policy, and you can depart from it for good reason. You can change it if you're the executive. But we know in our modern public law that policies must be followed absent good reason.
So, sorry, Mr. Hussain, I'm having trouble understanding where the constraint comes from in the words.
It doesn't. It's not clear in the words. It potentially comes from proportionate. That's the additional thing in the policy. I accept that when you look at the factors, that they seem open-ended, but the critical thing that gives you the constraint is the context and the purpose. The context is the policy regulating, if I can use that neutral word, let's use regulate for whatever it's doing. We say constrain, he says transparency promoting. It's regulating a discretion which the Supreme Court have said is concerningly wide. If it doesn't constrain, then the policy would enable the Secretary of State to prescribe all manner of organisations that satisfy that broad test. We say that the policy objectively construed, as the court construed it, is premised on a recognition that the definition is very broad of terrorism, the prescription power is very wide. Remember, belief and no requirement as to tempo or preponderance. And the results, very draconian. You put those three things together, width of the definition, see what Supreme Court say about that, the low threshold for proscription, belief, it could be one act out of however many, and the draconian effects, it makes a lot of sense that what the policy is doing is constraining discretion.
Mr. Hussain, looking at the 5 factors,
Yes.
Numbers 2 to 5 appear to be focusing the decision maker on the need to think carefully before proscribing terrorist organisations which have not very much to do with the United Kingdom.
Yes.
Because this is a worldwide power.
Yeah, absolutely.
And a lot of the proscribed organisations are
Yes.
foreign-based. The one that directly addresses an organisation which is only really active in the United Kingdom is really just the first one, which is very broad indeed, isn't it?
Well, literally construed, yes, but nature and scale. So what my lord, if Sir James is right, you just look at the nature and scale, and you say to yourself, well, it's really not very serious. It's at the outer edge of the spectrum, not part of the essence of the definition, but it falls within the definition. And you've got one act of serious damage to property. So that answers nature and scale. I'm going to prescribe. That's absurd. Think about the BMA organising a doctor's strike, the effect of which is to endanger health, for the ideological purpose of improving NHS provision and influencing the government Are they a terrorist group? An absurdly wide definition. The function of the policy is to constrain the absurdity of what is a concerningly wide definition being effectuated. That's our submission. So no, I don't accept that objectively construed, properly construed, it is wide, because the wide construction of the first factor gives you a totally perverse result.
So let's assume you're right. The purpose of the policy is to limit use
Yes,
of the discretionary power to prescribe.
yes.
I'm looking at paragraph 91 of the judgment. What did the divisional court mean when it said any other factor considered when applying the policy must be, quote, of the same nature?
Right, my lady's ahead of me. I want to say that a justum generis we don't defend. Our argument does not depend on a justum generis. The constraint in the policy doesn't come from the nature of the factors, because we accept that the need to promote international relations would give you a reason to prescribe when you might otherwise not. The constraint comes from the purpose of the policy. In that situation, the foreign relations situation, you would have a particular need.
So you don't seek to support that?
A justum generis appears twice, maybe more. It appears in 83, paragraph 83, and it appears in 91. We don't support the justum generis. The constraint doesn't come from the nature of the factors, it comes from the nature, the function of the policy, construed in context. Our third point is that the divisional court was right. So basically, we're going to say it got to the right result.
Corey, can I just be clear? Is that concession in your skeleton argument?
No.
And if so, where?
No, it's not.
And therefore, which parts of your skeleton argument do you no longer
None of them.
pursue?
We don't drop any of them.
Right.
I,
But which parts of the divisional court do you not
80
support?
83 and 91. 83.
It's the activities that comprise the nature, no.
Yes.
It's the last part of paragraph 83, isn't it?
Sorry, this is apparent from the other four stated factors. This 2, underscore 2. And 91.
So not activities in the first factor, not limited to terrorism. And,
Sorry, that is something we do defend.
right, so what do you not defend in paragraph 83?
I've lost my note.
Don't worry. Don't worry, we've got the, perhaps somebody in your team can help you. We have the clear concession on paragraph 91 that you do not support the suggestion that any, quote, other factor must be
Yes,
of the
exactly.
same nature.
It's clearer, insofar as 83, last sentence is justum generis. We don't accept it. On activities, sorry, this is a bit tricky and a bit involved. We submit they were right on activities.
Right.
91 is clearer. 91, second and third sentence. While we're on this, can I just give you something else that we don't defend? 79 on proportionality. We don't defend the reason the court gave for saying it's not ECHR, the contracting out.
You don't defend?
We don't defend 79.
Right, so you think it was bank mallet?
No. We think they were right in the result. It's broad proportionality. For example, the reasons you were giving, my lady, you haven't got the Article 17 problem. It's bank mallet style. We'd always said bank mallet style.
Right.
But the reason they gave there, contracting out, we don't defend.
I see.
Because you can perfectly, with great respect to the court, You can have a situation where the executive looks at
At what the court might do.
exactly. So I was on, I think, my third point.
Yes.
The third point is that they were correct to say, this is the key point, they were correct to say, given the constraining function of the policy as we submit it is, that what you've got to have is a particular need. The factors have got to contribute to explain the particular need to prescribe, above and beyond the necessary belief that the organisation is one that
That's
is
not what the
concerned
statute says.
No. It's not what the statute says. And the reason, I can completely understand my lady thinking, well, we would hesitate hard before we imposed a presumptive constraint. It's a presumptive constraint, but policies are not rules. You would be slow to impose a presumptive constraint on the exercise of statutory discretion in normal circumstances, but the circumstances are not normal, because what you've got is a definition that isn't just obviously very, very wide. I hope I'm not going to bore you to death by saying this. The Supreme Court have said it's absurdly wide. Lord Anderson, absurdly wide. Supreme Court, concerningly wide. Legislative narrowing, to be welcomed, can give rise to absurd results. I gave you the example of the BMA. It cannot be right that the policy says nothing about that. It would be very surprising if it did. And what is it doing when it's asking the second question? Statutory criteria met, proportionality. What's it doing if it's not doing that?
I'm not quite sure I understand by what you mean by saying a particular need.
Right.
Now, the circumstances in which the power arises and is capable to be exercised is in section 1.
Yes.
A public lawyer would read this as that's a discretion.
Not section 1.
Or
Section
whichever
3,
section it is.
Section 3(4).
3-4, whichever it is.
3-3
There's a
and
statutory
3-4.
test. It's a discretion, so you have to decide whether to exercise it.
Yeah.
And this says you've got to take into account particular factors. So if they didn't take them into account at all, they'd be acting unlawfully.
It doesn't just say that.
Well, this is what I'm getting at. When you say particular need, two questions. Are you saying something over and above the statutory definition?
Yes, of course. Of course. I'm saying that the Secretary of State has said to Parliament and to the public that I will only proscribe when it's proportionate to do so. And that's the additional bit in the policy. These are the factors that will help me decide that. That was going to be my fourth point. Those factors are designed to help her in answering that question of proportionality broadly construed in the way the divisional court did, i.e., does the benefit of proscription justify the massive cost of it? Now, in a lot of cases, Al-Qaeda, you get to particular need quite quickly, don't you? Nature and scale of activities, nature of the threat, international relations. So, no difficulty. The BMA, not quite. Us, we say they didn't identify a particular need.
So if
So-
you need something, is it just, it's not enough that it's serious damage
No.
to property, it's got to be serious damage to property, and over and above that, there's got to be something else.
Yes, it's got to be proportionate. That's what the policy says.
But that's not necessarily something, that's not a particular need. I think we all agree, if you're
think
right
that-
on Article 17, we're saying there is a proportionality requirement. If that's all you're saying, that's fine. But proportionality does not equate
Right.
to a particular need.
I'm going to say that the ECHR concept of proportionality doesn't exhaust the idea of proportionality here, because ECHR, it's a floor, not a ceiling, And the common law here goes further, and goes further for good reason, because you could have cases where the prescription is Article 10 compliant, but it's not proportionate in the broader sense. You may have the Article 17 issue. I'm sorry, I'm jumping ahead slightly for some of my points. And of course, your ladyships and lordships will be aware that the Supreme Court over the last 5 to 10 years have been very anxious to establish that, being reminded of the time, thank you, I'd asked for it, have been very anxious to establish that common law constraints and guardrails should not be subsumed by the HRA. There's a common law ground, and my submission is that it makes perfect sense in context for the particular need question to arise.
Is there any authority in support of your proposition? Any authority in support of your proposition in this context?
No, there's not.
And is there, I mean, we know that the policy, so-called, has been applied, I think, since its inception in many, many cases without question.
Yes.
And is there any judgment or decision
There isn't.
that will assist us on this point?
No, there isn't, but I understand the force of my lady's
No,
point.
it's an open question, I'm just checking.
Descriptively, no, but if there's anything behind that, my answer would be, look at the organisations that have been prescribed. Does one think that a question would arise on the policy as to whether or not there is a particular need to prescribe Al-Qaeda or ISIS?
Well, no, but there's another 96.
Yes.
And we don't know much about quite a lot of them.
First direct action group ever to be prescribed in 33 orders, serious property, damage to property alone. First time. Novel and unprecedented, by the way. We know that.
The other question, you say this is a constraint
Yes.
derived from the context, and you rely on the policy. And you accept the policy doesn't say anything specific about this.
Yes.
So
Accept.
really, why do you need the policy at all? What you're really saying is the statute needs to be read in context.
Well, we had argued Padfield. We'd argued Padfield. My argument was, before Mr. Justice Chamberlain, that Padfield tells you that you can only, Padfield means that you can only exercise this very wide discretion where it is commensurate with the consequences that follow to do so. And Mr. Justice Chamberlain said, put all of that in ground 2. He said ground 6 is duplicative of ground 2. And then your lordships and my lady said, no, it's not.
And just,
Remember.
fine, we are conscious of time and we will now let you just carry on, as it were. But can you give me the cross-reference in your very helpful open skeleton to the floor, not a ceiling, particular need point, because it's my fault.
Right, floor, not a ceiling, is something that I'm afraid I've just
Okay, but just
said.
the particular need point, just give me the cross-reference.
Particular
Perhaps
need
Somebody on
is-
your team can do that for you.
Yeah, please. Can you
Yeah.
do- I'm going to carry on.
Sorry?
The fifth
24 to 33, thank you.
specific paragraph, particularly. The fifth point is that the court was correct to hold at 89 that the Secretary had failed to act consistently with the policy by failing properly to assess whether there was a particular need. It found that the Secretary of State placed central reliance on an, quote, other factor, namely the general legal consequences of prescription. See Divisional Court at 89. Key matter, it said, an important matter, if not the central consideration, it said at 91. No challenge to that. And the problem with that, as my lady said very early on in this, it is identified by the court at 94, The problem with that is simply a description of the default legal consequences of prescription. They would apply to any organisation.
So I don't think the Divisional Court found that the Secretary of State failed to consider particular need.
Yes.
They didn't make that finding. They said what they did at 91. But what they did find was she had taken into something that was impermissible because it didn't fall within the definition of other factors. That's the key finding
exactly.
in
That's
94.
the key. As you said yesterday, my
Yep,
lady.
okay.
The key finding, and the real problem with that, is that if that reasoning is permitted, it would lead to the conclusion that prescription is warranted in almost every case. The policy would not serve its purpose because you would have those consequences they apply in every case. So that's the point. It's a narrow point.
And so you seek to uphold paragraph 94.
Absolutely. And 5 very quick points that I want to say in response. Proportionality I've already addressed. The second point is that we're not being legalistic. All we're doing is applying the policy in context. Tesco Stores Lord Reed says that you've got to do that if you needed authority for that obvious proposition. The 8th point, so it's the third point in response, is the meaning of activities. What does activities mean on the first question? First point is immaterial, as my lady noted. The second point is that you've got to...
It's immaterial on ground 1.
Yes.
It may be material on ground 2.
Material on ground
in terms of the approach adopted by the Divisional Court.
I understand.
Yep.
And then the second point is we say the policy isn't regulating a general dispensing power or a general criminal justice power. It's regulating whether you regard an organisation as terroristic. And therefore activities have got to be construed in the light of that and in the light of the statutory discretion which it regulates. The next point was international relations. I've already given you my answer on that, which is, yes, it could mean that you prescribe an organisation you wouldn't do otherwise, but that's consistent with our construction because that would give you a particular need. And the last point is that it is not the case that the Secretary of State is precluded from looking at the operational benefits. She absolutely could look at them, provided either they showed a particular need or the other factors did. So those are my submissions. Yes, gone over very slightly. Unless there's anything else,
Well, we've
I'm going
contributed
to
to the
now
delay, but
address
it's been
you.
very helpful. Thank you for answering our questions.
Not at all, my lady. Thank you for asking them. Round 2.
Yes.
Schwidler, 30 seconds. Paragraph 46 of our skeleton might be prudent to do what the court says at 163, i.e. apply a review as well as a fresh assessment approach. You've got to have special reasons or compelling reasons. That's all I want to say. And then on the issue of Article 17, scope and less intrusive, Mr. Greasel is going to address you.
Thank you.
Thank you very much.
Yes, Mr. Rubin.
My ladies, my lords, I will address you, as Mr. Sen said, on 2 discrete points, Article 17 and scope of Articles 10 and 11, and less intrusive measures. There is quite a bit of grounds to cover. I don't propose to turn up many authorities, but I will be providing references as I go. It would assist to have our skeleton arguments to hand.
Yes.
I'm going to take as read the general principles which we outline at paragraph 44, namely that the rights to freedom of expression and freedom of association are recognised as fundamental rights, foundational for democratic society, and also, in particular, any measure which consists in the outright dissolution of an association is obviously a very exceptional measure that could only be taken in the most serious cases. Moving to Article 17. in my submission, the Secretary of State is simply wrong when it's submitted on her behalf that Article 17 means that any statements in support of a prohibited organisation, any activity of a prohibited organisation, any activity which amounts to significant damage is automatically outside the scope of Articles 10 and 11 by virtue of Article 17. That's simply, in my submission, an error. It doesn't meet the European case law. It doesn't meet the domestic case law. The consequences of it are obviously stark because it would take almost everything done by Palestine Action outside of the convention grounds that we rely on. The high point that, in terms of the case law on which my learned friends relied, is the case of Raj TV and Denmark, and my learned friend seeks to derive from that the proposition that Palestine Action are outside the scope of Article 17. Essentially, for the reasons identified by the divisional court, that's a misreading of that case. My learned friend relied on paragraphs 31 of that case. If one,
So let me just remind, in the judgment below, which paragraphs?
it is in the district court's ruling at paragraph 112.
Yes,
Paragraph
112.
112.
So, on the facts of that case, the organisation concerned was involved in the promotion of the PKK's terror operation. There was repetitive incitement to participate in fights and actions, incitement to join the organisation, or the portrayal of deceased guerrilla members as heroes. And it was not only a declaration of sympathy, but it was essentially propaganda for the PKK. That and it included, and this is the following paragraph cited at paragraph 47, incitement to violence and support for terrorist activity disseminated to a wide audience. Those facts in my submission are very different from the present case. And if one looks at the cases cited in the Raj TV case, to give an example of the types of activity which fall within Article 17, it is the cases cited, and this is paragraphs 32 through to about 38. It's Holocaust denials, Islamophobic and anti-Semitic statements. It is statements which not only call for the denial of the state of Israel's right to exist, but call for its violent destruction and the killing of its inhabitants. Those are the sorts of statements and the sorts of aims which put one in Article 17 territory. Also refers to the case of where there is an unequivocal calling for the use of war crimes and summary executions. Those are the sorts of actions which brings one in Article 17 territory. It is simply not the case that any statement by an organisation which is prescribed at domestic law falls within Article 17. My learned friend, in fact, refers to the case of Sabuncu in Turkey. Again, I won't ask you to turn this up, but it's tab 68 of the bundle. And that case, my learned friend referred to earlier paragraphs in that, but he didn't take the court to paragraph 222, which is cited by the divisional court in paragraph 114 of the judgment below. And that says, in terms, that freedom of political debate, which is at the very core of the concept of a democratic society, also includes the free expression by prohibited organisations of their views, provided that these do not contain public incitement to commit terrorist offences or condone the use of violence. A statement in terms that the fact that an organisation is prohibited as terroristic doesn't put all its statements outside the scope of Article 10. And in fact, that very paragraph goes on to say that it is apparent from the court's case law that where the views expressed do not comprise incitement to violence, in other words, unless they advocate recourse to violent actions or bloody revenge, justify the commission of terrorist offences in pursuit of their supporters' goal, or can be interpreted as likely to encourage violence by expressing deep-seated irrational hatred towards identified persons, but persons not property, contrasting states must not restrict the right of the general public to be informed of them, even of the basis of the aims set out in Article 10.2. So this establishes it's not only Article 7, that they're not within Article 17 restrictions, it's even Article 10.2 doesn't suffice to restrict the dissemination of those views outside of the calls for violence against persons as indicated. And again, I don't ask the court to turn them up, but we give a number of references in our skeleton argument. It's paragraph 50 of our skeleton argument. Cases are in footnotes 86 and 88. Ekrem Khan in Turkey, Gül in Turkey, Kilik and Eren in Turkey, all cases concerning statements made by prohibited organisations, in most cases the PKK, all cases where the court rejected arguments that Article 17 applied. In fact, in many cases found a breach of Article 10. The position of the Secretary of State is also contradicts with domestic authority. The Court of Appeal has accepted in Chowdhury that offences relating to support for prescribed organisations engage Article 10. The Supreme Court did the same in the case of PWR. The Supreme Court did the same recently in the case of ABJ. And in ABJ, the Supreme Court has taken to a number of the cases relied on by my learned friend, the HTT in Germany case, and so was well aware of those authorities, but at no point said the simple fact that an organisation is prescribed means that Article 17 applies. And so, in my submission, there is simply nothing to the point in the reliance on Article 17. There is.
Are you going to address AG Ref, the main authority relied upon by Sir James?
In terms of, yes, in terms of whether the Attorney General's reference, what I might term the Colston statute case, that is a case which turns on whether or not conviction for criminal damage is proportionate. Mm-hmm. It is of very limited assistance in terms of the scope of Article 10 and 11. In my submission, the suggestion that significant damage automatically falls outside the scope of Articles 10 and 11 is incorrect. And in fact, the case where that proposition received greater analysis is the case of Hallam, which was a case in which my lady sat, and it was made very clear in that case.
Hallam. H-A-L-L-A-M.
Made very clear in that case that that it was wrong to conclude that simply because damage was significant, that it would fall outside the scope of Articles 10 and 11. It may well be proportionate to convict someone for an offence of criminal damage. They may not have a defence at criminal law to that simple criminal offence. But that fact doesn't mean that all bets are off, as it were, and that any sentence could be imposed without any risk of breaching Articles 10 and 11. In fact, the contrary is the case. Article 10 and 11 play a role at the sentencing stage, and that's precisely because the conduct remains within scope of Articles 10 and 11. So, action which compromises damage to property by itself, not outside scope. course, there may be circumstances in which if it's done in a violent manner, that would be different, but simply spraying paint on something doesn't take one outside the scope of Articles 10 and 11. Conduct which causes significant financial loss doesn't take one outside scope of Articles 10 and 11. That case of Trowland, again, another case in which my lady sat. So these cases are all very clear that none of these points on which my learned friend relies means that Article 17 is engaged or that there's any issue with scope. And there is a very big difference between the proportionality of a simple criminal conviction under the ordinary criminal law for an offence of criminal damage and prescribing an organisation as a terrorist group and all the consequences which follow. So the fact that the former may be proportionate certainly doesn't mean that is so. It's so not only is the points on scope which are being advanced in this court on behalf of the Secretary of State at odds with European law, they're at odds with domestic law. They are also, as my lady noted, at odds with the approach taken by the Secretary of State herself when making her decision, because it was considered that Articles 10 and 11 were engaged, at least in terms of some actions, and that's well documented in the documents in the file. So there is simply no authority which says that damage to property alone puts an individual or an organisation in the realms of Article 17. A single European authority for that proposition. Unless there are any questions on that point, I'll move on to less intrusive means. This, again, is in our skeleton argument. It is at paragraphs 53 to 64. Two headline submissions at first. The first is that the Secretary of State simply failed to identify and consider all of the various alternative means which were available to her description. And secondly, insofar as consideration was given to alternative methods, that analysis was flawed. The test, of course, is uncontroversial. The test is whether an alternative measure could be used without unacceptably compromising the objective. So exact parity isn't required. There is a degree of flexibility. And our submission is that there were plenty of alternative measures that could be used. We say they could apply as a suite, so we don't have to point to one individual one, and those provided, as the divisional court effectively found, although its reasoning was under fair balance, much of what the divisional court said about the use of the ordinary criminal law also applies under less restrictive means. We set out at paragraph 55 of the skeleton argument essentially 6 different categories of alternative measures. I'm going to address 3 of them, and I'm going to start with criminal prosecution for non-prescription criminal offences. So this is in our skeleton argument. It is paragraphs 55, and it is 55.2. And we list there a number of very straightforward criminal offences which could be used to target some of the actions of Palestine Action. Clearly criminal damage, clearly aggravated trespass, public order offences. It is important that a number of these offences can be applied to those in organisational roles within Palestine Action. It is, for example, simple offences of conspiracy at criminal law apply to those who are organising actions which amount to criminal damage, for example. There is also, and of course, one doesn't have to wait for the criminal damage to occur before arrests can be made, before prosecutions can be brought. One doesn't even have to have specific identified targets necessarily. These measures are used to prosecute sophisticated criminals in all sorts of areas. Sophisticated drug dealing operations and the like are prosecuted under these measures, that they are available and can be used if it is considered necessary to deal with any group which are planning criminal activity. There is also, in relation to statements made, the possibility to bring prosecutions for the encouragement of crime. That's referred to under the Serious Crime Act 2007. There would even be the potential to bring prosecutions for participation in the activities of an organised crime group, if it was felt that Palestine Action even went that far. These are all measures which can be brought in advance of any action being taken by Palestine Action. So that the suggestion that's made in the document, particularly by the counter-terrorism police, was that these were somehow only reactive measures, is simply incorrect. It's perfectly possible to bring these sorts of prosecutions. And of course, a number of the offences I've mentioned are serious offences. They carry serious penalties. And they provide, in our submission, a perfectly adequate response under perfectly normal principles of criminal law. There, as well as the prosecution under the ordinary criminal law, there is the possibility for bringing prosecutions for ordinary criminal offences which are alleged to have a terrorist connection, which it gives the potential for increased sentencing. There are, if it is considered that aspects of Palestine actions cross the threshold into terrorism, there are terrorism offences which can be used, which do not depend on prescription. So all of this is available. Some of the objections which seem to have been taken by the counter-terrorism police, referred to in the documents provided to the Secretary of State, refer to Palestine Action being accused of seeking to stifle a strange justice system and employing legal defence teams to hold law enforcement to a strict liability of proof. That is an unusual submission to make. It would appear that the role of most
Could you just
defence
remind us, we have been taken, you said that the Secretary of State failed to identify and consider. In the submissions to her, where do we find the considerations of alternative, less intrusive measures?
It is primarily, it's in the Min Supplementary Bundle 1, tab 10B,
Thank you.
page 177
Thank
in
you.
hard copy.
Thank you.
Electronic, I think that's 186.
Yes.
So this is the most detailed analysis that has been provided. But the suggestion that these offences weren't capable, are somehow, in principle, incapable of addressing the organisational capacity of a group like Palestine Action is, in my submission, simply misplaced. There is consideration of the use of, for example, behaviour orders, which is the second point that I wish to come on to. That is on page 176. Only two forms of behaviour order are cited. criminal behaviour orders and serious crime prevention orders, it is stated that in relation to serious crime prevention orders that they may be made on conviction. That's correct. They can also be made without conviction, so that they aren't dependent on a specific individual being convicted. It is unusual that the objection taken to the use of those orders is that it would require the courts to consider Article 10 and 11 rights before imposing such orders. But how prescription avoids such a problem is unclear, because prescription is clearly a far greater infringement of Article 10 and 11 rights. The advantage of behaviour orders would allow a tailored consideration of Article 10 and 11 rights in relation to particular individuals and their roles. The third alternative measure which I would seek to rely on is that of civil injunction. And there is simply no evidence at all that this was properly considered by the Secretary of State.
Well, she couldn't get a civil injunction, could she? You're suggesting private law litigation by third parties at their own cost and risk, assuming they can get the evidence together.
Well, the circumstances in which public bodies can obtain an injunction in support of the criminal law are limited. It would primarily certainly be the private companies that would be doing it, but it is the Article 1 protocol rights of those companies which are an issue.
Secretary of State has no power to compel any third party to bring civil private law litigation.
No power to compel, but is able to support if necessary, and has supported in the past. The police have provided evidence to private companies in order to obtain civil injunctions. They've been supported in doing that. And it is a measure which has been used, I wouldn't say routinely against protest groups, but has been used again on a number of occasions, and has often has been very effective at stopping more extreme aspects of protest activity. The recent litigation in relation to Just Stop Oil is one example. Just Stop Oil have stopped their campaign of obstructing highways. A big factor in that were the number of injunctions that were taken out to address that.
Well, there are a lot of prosecutions, convictions and sentences as well.
It's the combination. It's the ordinary criminal law, and we targeted injunctions on particular cases. Those injunctions are a far more sophisticated instrument than prescription, because it addresses the particular behaviour and conduct which is considered to be at issue, rather than a blanket prohibition on the entire organisation. The proceedings for contempt of court can be brought very quickly and can result in very significant prison sentences and very, very significant costs. It is possible to have organisations named in civil injunctions, so it doesn't have to be specifically either against individuals or persons unknown. And there is very little by way of the sorts of behaviours which the Secretary of State seeks to rely on in support of prescription that couldn't also be covered by way of an injunction. And there is, in fact, one example prior to prescription when one site targeted by Palestine Action did obtain an injunction. And that the evidence of that is in relation to the Teledyne site. And it is set out in the statement of Kevin Blow. I won't ask.
It's in the judgment as well, isn't it?
Yes.
Yeah.
And the simple point is that there were a series of actions at that site for approximately 6 months before the injunction was obtained. And once the injunction was obtained, activity by Palestine Action effectively ceased. I think there was one action on the date the injunction came into force. So the one time it has been tried, it has, the evidence shows that it's been very effective. And the fact that there is simply no consideration at all of supporting relevant organisations to obtain such injunction and jumping instead straight to prescription is, in my submission, a very significant flaw in the section status. Unless I can assist
You've been
further.
very helpful. Thank you very much. No, thank you very much indeed. Yes, back to you, Mr. Singh.
Back to me, my lady. Oh, could you just take this? I'm very grateful to Mr. Greenhall for stepping in at very short notice.
Yes, it's done very well. Thank you.
Very kind of you to say. I respectfully concur. My ladies, my lords, fair balance then. I'm going to address you on impact, skeleton, at paragraph 67 to 68. I hope you've got that with electronic numbering.
Yes.
We will give you a skeleton which adds everywhere e-numbers. I'm very sorry we haven't had time to do that up
Well,
to
I
now.
think that we've come to the end of the road with fresh documents because we'll
Right.
now be marking everything up.
Yes, no,
and
you're
I
absolutely
think
right.
We'll just,
Okay. Yeah,
subject to
we'll,
what my
we'll
lord
leave
has-
that, sorry.
You may want an updated one actually, but
Yeah, what happened is we found out very late that there was this problem. I was working off hard copies, so I'm so sorry. So firstly, impact. Secondly, the Secretary of State's case for prescription. Our skeleton at 69 and also 17 to 23. So we'll look at the decision-making, look at bright lines, violence, escalation, the manual, anti-racism, national security, Bryce Norton. And then finally, deference. I'll probably just do that by reference to the skeleton, depending on how much time we've got. Paragraph 70 to 71. The points are perhaps pretty obvious. Before I get to impact, errors in the divisional court, if you do conventional review, no errors, deference, no error as to the margin that was afforded. Second error, Sir James advances, is escalation. Did they fail to have regard to escalation? Our answer is no. Secretary of State was aware of the court was aware of the Secretary's case on escalation. See Divisional Court 3, 34 and 43. The complaint is that Divisional Court 140, they focus on the activities not yet in level, scale and persistence, crossing the line. Persistence, we say, denotes forward-looking as well as backward-looking. The previous paragraph, they were looking at the hypothetical potential for future prosecutions. That's all I want to say. Obviously, none of that matters if you're doing Schwidler. So, impact. So, please can I ask you to keep our skeleton open, or the new document, because that's got the e-references. And I hope the first thing that you've got is paragraph. So it's 67, please. I thought you just had the extract. Paragraph 67. I'm going to address you on some of the key categories of people who are impacted. And I hope this chimes with some of the concerns and questions which my lords, my ladies were asking yesterday. So the first category is Judgment 135, Skeleton 67.1, and this is the category of people who pre-prescription were either members or supporters of Palestine Action. Now, Sir James characterised those people as being a relatively small group of hardcore direct activists, implicitly a group that supported acts constituting Section 1 terrorist conduct or acts of violence. But that is just contrary to the evidence. It's contrary to the Secretary's own material. Palestine Action was a group that enjoyed very considerable popular support. Please see our footnote 177 for the references. What did I say? 117, sorry, footnote 117, I'm so sorry. 117, so over 20,000 mailing list and over 500,000 on Twitter, X, Instagram, TikTok, and the ministerial submission accepts all of that. SB1, tab 10, min sub, para 8, hard 146, soft 155. Now, these are people who supported or engaged with or participated in Palestine Action in a variety of ways, for whom Palestine Action was a vehicle for their rights of expression and association. But it's possible further to differentiate this group and to look at the relative impacts on their rights. Those people include people who were, one, consuming and engaging with the educational content which Palestine Action distributed, chiefly about the role of UK-based arms companies in atrocity crimes committed in Israel. Two, includes people who joined in with Palestine Action in conventional, demonstrative, expressive protest activity, so demonstrations, placards, and so on. Three, people who engaged in conventional, disruptive direct action protests, which, although we accept, would involve breaches of the criminal law, are unequivocally not the actions of a terrorist group. I'm thinking of lock-ons, sit-ins, blockades, minor damage to property. That's Ammori 1, paragraph 29, supplementary 1, supplement 1, tab 5, page 49 hard, soft is 58. And please remember, as I said in opening, JTAC endorses that. It agrees with it. It says in its assessment, and this is tab 10A, supplementary 1, tab 10A, page 160 hard, soft 169, paragraph 7, it assessed that the majority of Palestine Action's direct action would not constitute an act of terrorism on the basis any damage to property is typically more minor. Common tactics include graffiti, petty vandalism, occupation, and lock-ons. And then, yes, a fourth category, a smaller cohort engaged in more serious damage to property. So that is the more involved answer, as I put it, to my Lord the Master Rolls question about Lord Justice Leggett, as he then was, and Rawls on the facts. And more serious damage to property has historically not been considered as terroristic in this context. The government has exercised restraint. Whether or not it qualifies as civil disobedience in the Rawlsian sense doesn't matter. The point is that it's been accommodated and treated with a sense of proportion. Criminal, yes. Terroristic, no. And if you are interested in some of the references to the suffragettes, my lord mentioned them yesterday, you see Professor Howard, Supplementary 2, in the hard copies is Volume 3, tab 46, hard 81, sorry, that's just wrong, hard 810, and soft 825, paragraphs 26, 27, and then you also have it in Mr. Sam Grant from Liberty, paragraph 5, his second statement, paragraph 5, supplementary 2 in the hard volumes, it's the third volume, tab 57, hard 1035, soft 1050. I will address you on the manual, of course I will. In terms of determining the size of that cohort, the fourth cohort, more serious damage to property cohort, my lord made the point that the relevant measure wasn't exclusively the number of actions, 3 over 385, but another way of thinking about it, to look at the number of people involved. Now, Tails, the first incident, that's 5 people. Tab 10A, hard 163, sorry, thank you. 163, E172, para 25. Para 25.
Sorry, what's that reference to?
5 people at Thales. I'm giving you the numbers.
5 people.
The numbers of defendants involved in the 3 incidents.
Right.
If you're not interested in it, I can do it very shortly. The headline point is going to be, it amounts to about 35 people out of hundreds and thousands
That's what we
of-
need, I think.
Sorry?
I think that's all we need.
That's all you need.
I'm just quite
But-
interested in the evidence for that. You gave a reference, but you didn't give me a soft page number.
I thought I did. So Thales is E172, and it's paragraph E172,
E.
electronic.
Oh, I see.
Sorry, soft.
Supplemental bundle 172.
Yes, sorry.
Yeah, okay.
Paragraph 25. Intra-precision. There are 9 defendants. I'm afraid that's from open reporting. It's not in the evidence. Sorry about that. And Filton, 24 defendants now. At the time of the JTAC assessment, it was 18. Supplementary bundle, soft copy 171. Paragraph 22. For those of you in hard, it's page 162. The effect of prescription, of course, is the same for all. Their expressive conduct, their association, becomes not just criminal, but terrorist. The obvious inference is this will include thousands. It's not too high to say perhaps hundreds of thousands of people who've never engaged in acts which constitute Section 1 conduct. So that's the first category of people impacted. Pre-prescription members or supporters. Second category, the people who post-prescription campaign in support of Palestine Action.
Hang on.
For
So
deprescription.
you're not following paragraph 67,
Right, I've now gone to 67.3.
right?
I'm not going to sorry, I'm trying to pick up the
Okay, so you said you don't want to add to 67.2.
no.
Right, thank you. The 67.3.
I think I may come back to it. Sorry, I'm going to come back to it. That's a response, so I'm going to come back to her at the end, if I may. So 67.3, people who post-prescription campaign for deprescription of Palestine Action. Skeleton 67.3, judgment 118, we say, divisional court, wrong, respondent's notice point, wrong to allocate little weight to that. This is a cohort of people who, whether or not they were previously members or supporters of Palestine Action, now do support Palestine Action and or wish to advocate for their deprescription. The obvious point is that holding up a placard saying, I support Palestine Action, is, without more, a terrorist offence. It's a strict liability terrorist offence, section 13. So even if a person might mean, I support Palestine Action, not because they support violence, not because they support section 1 conduct, but because they support the low-level civil disobedience, which was the vast majority of the actions, or the holding of placards, or the demonstrations, or the consumption of the knowledge about arms complicity, which Palestine Action was engaged in distributing, Section 13 draws no distinction between those people. Intention is legally irrelevant. But it's not just people who are engaged in that kind of classic Rosa Parks civil disobedience. All expressions of support are now criminalised per section 12. Someone who might wish to say, I think it was a good thing that Palestine Action were inhibiting the work of Elbit Systems because I think Elbit Systems were complicit in atrocity crimes, that's a terrorist offence. Many people agree with, would express support for, the actions of XR, Just Stop Oil and so forth into late Britain. Even if those organisations have engaged in or encouraged unlawful actions, unlawful destruction of property, they are free to say that. Not so with Palestine Action. By executive fiat, such expressions of support are now terroristic. The third category in our skeleton, people who aren't, that I want to talk to you about, who aren't members or supporters, but who are subject to chilling effect. So the evidence here...
So 67.4?
Yes.
Right.
Yes. So the evidence is that there are people, many people, are so concerned by the risk of committing or accused of having committed or being arrested for having committed, having work terminated for having committed, any of the offences that they self-censor. And you might think, well, that's fair enough. Serious terrorism offences, it's responsible, indeed rational, to seek to avoid even the accusation of having committed such an offence. But that has very serious consequences for free speech on a matter of the most acute public interest. Concrete examples that we've given you in our skeleton, I'm going to pick out three. Firstly, campaigning civil society organisations. That's our skeleton 67.4. The court below said they faced, quote, general problems. That's paragraph 1, 2, 3. Amnesty's evidence, their concerns regarding prescription offences fundamentally changed their campaigning and advocacy work. It constrained their media work. It limited the encouragement they could provide their members to campaign and take action in relation to civil liberties concerns. Footnote 137 gives you the references. If I can just give you the paragraphs, which you haven't got there, it's 21 to 28. CEO of Amnesty. Liberties evidence, similarly, prescription limited liberties work in campaigning. They ceased public-facing work on prescription, ceased engagement with parliamentarians on the issue, declined numerous media requests, took steps to limit information which Liberty volunteers provided to concerned members of the public. Footnote 138. You don't have the paragraph numbers, they are 18 to 29. The court below were right to accept that those were genuine problems caused by the Section 12 offence. Second class of chilled speech groups. Other groups, this is skeleton 67.5. Judgment 119 to 20, we respectfully say wrong to place little weight. Other groups concerned in direct action or campaigning against Israel's violations of international law.
Sorry, which bit of the judgment below?
119 to 120.
Lovely, thank you.
And a couple of examples. Dr. Amy Shalan, she is the chair of the British Palestinian Committee. She described how proscription created a, quote, culture of fear amongst those campaigning for Palestinian rights. Footnote 140. She explained that members of the Palestinian community in Britain involved in campaigning and advocacy work routinely faced legal threats, including allegations of being terrorists or terrorist sympathizers. And that's before proscription. NetPol, this is the Network for Police Monitoring, an organization seeking to monitor public order, protest, and so on, was overwhelmed by queries from members of the public concerned that their attendance at demonstrations in support of Palestinian rights would fall foul of proscription. Footnote 141. Campaign Against Arms Trade reported contact, again, from people in the public who were concerned they couldn't anymore say Free Palestine or display a Palestinian flag for fear of being labelled terrorists. Footnote 141 again. To be clear, the concern here isn't that those concerned members are in fact at risk of being prosecuted, but that the climate that proscription creates means that many, many people will have to self-centre to a greater degree than is actually required. That is chilling effect, of course, in action. Third category, media organisations. Skeleton 67.7, judgment 123, responsible journalists self-censoring on a matter of real and significant public concern. Circumstances of proscription require journalists to take unprecedented editorial decisions where they are afforded no exemption from criminal liability and no guidance in relation to journalists. See the evidence at footnote 147 of our skeleton. That problem is exacerbated, we say, by the overbroad and uncertain exercise of police powers. With respect, the court was wrong to dismiss those concerns. I want to be clear, there's no challenge here to the lawfulness of any particular arrest or police conduct in the material, nor to the proscription offences themselves. But we do submit that the breadth and nature of the proscription offences is relevant to the risk of overbroad police action. That's one aspect of the practical consequences of the decision. First, contrary to the court below at 119, there are particular features that arise in this context, which make the possibility for such police errors a particular feature.
And where are you in your skeleton now?
Skeleton at...
Is it 67.5B?
I think you're absolutely, exactly right, thank you.
67.5B.
Yes.
Thank you.
So we say that whether or not a person has committed an offence contrary to sections 11 to 13 can in practice turn on relatively fine distinctions. Was the person's statement an expression of support for the proscribed organisation itself, or merely an expression of support for its aims and objectives, which are shared by that organisation, ABJ 61, which Sir James showed you yesterday? is the symbol which the person displayed a symbol which a reasonable person would associate with supporters of the organisation, or merely supporters of a broader cause or movement? You say police officers, in deciding whether they've reasonable suspicion, have to make relatively fine judgments. The inherent nature of the offences gives rise, we say, to an obvious risk of genuine confusion. The difficulties are particularly acute in the case of Palestine Action. Loose network of activists concerned about the situation in Palestine, a real risk, we say, very real risk of police being genuinely and innocently confused between Palestine Action and some other non-proscribed direct action protest group. Liberty and Amnesty also make the point in their submissions, para 39, core bundle 36, page 322, soft 476, para 39, and this is a point to which Sir James does not respond, that the effect of section 12.2 of the Act is to criminalise the arranging of a meeting to further the activities of a proscribed organisation. Where a direct action protest group is proscribed, that potentially criminalises any attempt by individuals or organisations to coordinate in continuing direct action protest under an alternative banner post-prescription. That is to say, there's a risk that future direct action on similar matters to those with which Palestine Action were engaged would be said to, quote, further the activities of Palestine Action, to keep it alive post-prescription. Secondly, the second point on this, we say the court below was wrong to say those issues were likely to improve over time and were in any event remedied by guidance. That wasn't a proper answer. Even with guidance, the points about the difficulties arising from fine judgments would continue to apply. In any event, the guidance document upon which the court below relied at 119 is unpublished. It offers no assistance to persons liable to be affected by overbroad policing tactics. They can't know the contents. They can't regulate their conduct. They can't, in the face of wrongful police conduct, rely upon it to avoid arrest. And in any event, the court's approach, we respectfully say, gives inadequate weight to the fact that police conduct in question, stop and search, questioning, more seriously, arrest and detention, all themselves amount to interferences. Then there's a broad point of principle at the end of 67.3 of our skeleton footnote 169. We give you a reference to Lord Bingham in the first Belmarsh case, where he said, his lordship said, that overbroad legislation touching on the liberty of the individual is not saved by, to be regarded as saved by concession or undertaking and so forth. The issue in that case, Sir James will remember this, the issue in the case was whether the power of internment, which applied to suspected international terrorists, extended to, for example, members of ETA who did not pose a threat to the life of the nation. Lord Goldsmith had given an undertaking in that case to say, well, we won't apply it to ETA, we'll just apply it to ISIS and I think Al-Qaeda. And Lord Bingham said, no, that's not good enough. The legislation's overboard. And then, my lady, my client herself the impact on her, 67.2. Sorry to take it out of order. Judgment 122. Impact has been severe, resulted in the destruction of much of her life's work, severely restricted her exercise of her Article 1011 rights. By way of illustration, this is judgment 121 and 122. She's been deplatformed because organisers are scared of committing offences. She's been compelled to self-censor. Her every word is now monitored closely. She's very concerned about the risk of inadvertently committing offences under Section 12 of the Act. She's been forced to stop participating in protest activity, a core part of her identity and self-expression, for fear of exposing herself. And that is Ammori 5, supplementary tab 9, paragraphs 9, paragraphs 12, pages 143 and 144 in hard, and 152 to 153 electronic. And also Ammori 1, supplementary 1, tab 5, para 40, hard page 51, soft 60. So those are my submissions on the very wide-ranging and very considerable impact of this decision. I want to now address you, please, on the other side of the balance and look at the basis for the Secretary of State's decision. We see from the March Min Sub, that the basis was Palestine Action commits or participates in terrorism, 1, encourages, 2, prepared, involved in preparing, 3. And the reference is Min Sub, tab 10, paras 12 to 17, hard 147 to 148, soft 156, electronic 156 to 157. Can I please, and we know that 3 actions were assessed under the first limb. So I'm now on commits or participates 3 out of 385. And we have this in the Min Sub at para 14 in those pages I gave you. 4 points I want to make. So the 3 incidents, you know, Tales in Glasgow, June 22, Instro Precision in Kent, Sub Judice, June 2024, Elbit in Bristol, Sub Judice, August 2024. 4 points, please. First is that the decision to proscribe Palestine Action was based exclusively on Palestine Action having caused serious damage to property. We see that from the PRG noting at tab 10 in that document, in the Min Sub document at para 10, there's no known precedent of an organisation being proscribed on the basis that it was concerned in terrorism, mainly due to its use or threat of action involving serious damage to property. So James says, well, there's no bright line. Maybe he's exploiting the use of the word mainly. I'm going to come on to that. There's no suggestion there's any other limb, but it's a line of dramatic importance. And if he's right, and there's no bright line, and well, one wonders why he forensically makes that point, but if there's no bright line, then the consequences should not be so consequential. And we might say that the only reason why he can say there's no particular bright line is because the definition is so broad. But it's serious property damage, nothing else.
But when you're
What-
looking at national security,
Yeah,
damage to property may be a far bigger threat
yes. It could,
than violence to persons. So
No, it could be, and I'm going to address you on the facts. It's property rights with knock-on on defence. I'm going to come to that, my lady. But they rely on 3 incidents. It's serious property damage in the form of these 3 incidents. And that's it. And over 5 years, 385 actions. Why isn't there reliance on anything else? Well, we rhetorically ask, we would answer that by saying, if you look at the contemporaneous documentation, this is the second of my 4 points, the Home Secretary assessed that Palestine Action does not advocate violence against persons. I already told you
Palestine Action
does not advocate for violence. I already told you yesterday that that was the assessment in March 25, JTAC, and in the community impact assessment. Would you like me to give you the references again? I gave them to you yesterday.
You can if you want. Yes.
So the references,
That's fine.
references are, I'll do it quickly. References are JTAC, para 36, 10A, tab 10A, hard 164, soft 173, and then the community impact assessment, tab 10E, hard 191, soft 200. And I had said yesterday that this was a consistent view before that March assessment, and it remained that view after the March assessment. And I would like you to just take up just a few documents, if I may. I don't think you've gone to them yet. And it's the agreed supplementary bundle. And I think it's the first time that counter-terrorism policing looked at Palestine Action. I think it's the first. And that's the report of 27th of June 24, and that's supplementary 1, tab 17, hard 233, soft 242. And if you could just keep this open, I'm just going to quickly gallop through some of these documents. So if you look, please, at that page, 2/3 of the way down the page, we see Palestine actions very rarely involve offences against the person and are mostly confined to criminal damage investigations. 233, James, to James, and 2/3 of the way down. Have you got it? Here. In between the redactions.
Could you read the paragraph by the first one?
Whilst not targeting a financial institution, members of PA broke into the promises of institutional position. I'm going to come on to all of this. Of course, going to come on to all this. Institutional position is dealt with. Okay, the next document, please, tab 18, and it's page 246 hard, 255 soft. So this is a briefing from the National Police Coordination Centre, September 24. And if you look, please...
Sorry, just going back, forgive me. I think that statement about very rarely involving offences against the person
Yes.
was effectively the position before Instro. That's the point. This is a step up.
Well, let's...
You see what I mean?
I completely see what you mean, and that's...
Because
in fact,
self-evident-
I don't think it was... It wasn't...
Well, if you
I
look,
think
if you
it's
look at
early
what's,
June.
if you look at what's above, that's, I think, the point that was being made. Anyway, there we are. You've got another reference.
Oh, sorry,
for
it's a
us.
step up. Sorry. No, you're absolutely right. I'm sorry. But the assessment doesn't change.
Good.
That's
So
the point.
Show us that.
Okay. It's the next document, September 24,
Yes?
and it's at page, I think I said page 246,
Thank you.
hard 255, and in soft, and it's quite difficult to read, certainly for me. It's gisted, and it's the top of the page, and it says, violence has been observed at 2 direct action incidents in recent months. You see that? And so they're referring there to Instro and Elbit,
Yeah.
because Elbit is August.
Yeah.
And this is not the norm for PA action, and any harm or injuries historically are assessed to be the result of unintentional or misjudged action through trying to evade capture. And then the same thing, the same body, says the same thing in December 24 at tab 21, hard page 268, soft 277. They say the same thing at the top of the page. In the second sentence on the page that we can see. 268 hard.
Yep.
It's this, my lord. 268.
No, I was looking at something else. I wasn't paying attention.
268 hard, 277 soft. And towards the top of the page, the second sentence that we can see, that violence is not the norm tactic used by PA, despite isolated incidents in 2024 that provoked arrests under TAC legislation. And then the gisting, any violence or harm is assessed to be an indirect consequence of attempts to evade apprehension or has occurred in isolation from a singular lone group nominal.
Mr. Hussain, can I just ask,
Yes.
that's the assessment by the police.
Yes.
What is the respondent's case about that, in fact?
Well,
Is she saying that these were two effectively things which happened contrary to Palestine Action's wishes?
well, I'm not sure that I hope you'll understand obvious reasons why I can't help you on that.
Is there anything in the...
Her consistent position is, I think, across 3 statements, that they have never advocated for violence against persons, harm to persons. I gave you the references.
Yes,
I can
we've
do that
seen
again.
There's no other evidence.
No. But they have never advocated for it.
Never advocated physical violence
Never.
against people.
Never. Would you? I gave you the references yesterday.
Yes,
I'll give them now again.
I've got those.
It's quite important
Yes.
that we have that. She's very emphatic about it. And we are emphatic about it. This is not the norm tactic. It's happened. Yes, we can't say very much about it for obvious reasons. It's not, look what the police are saying on their side about this. Never mind what we say, look what they say. And then we see in the June 25 Min sub, at page 222 in this bundle, hard, soft is 231. And this, we know from 233, top of the page, hard 232, this is after the Home Secretary had agreed to proscribe, but she then decided not to do that and requested further advice concerning activity since Elbit, effectively. And so 10 months later, we get the assessment. And the assessment is at the bottom of that page, activity since August 24, 158 direct action events, different business premises regions, of those 185 events, 28 have been described as higher level direct actions, not official definition, damage and cost of repair over £50,000. For example, a lock-on event at a height requesting specialist policing resources and an inner-outer cordon, 159 arrests have been made. So, nothing here about violence against persons and nothing about serious damage within the definition. So that's the second point I wanted to make. No wonder that all the Secretary of State has about violence is Sir James's advocacy. If she had a case on violence here, it would be irrational, even on the belief threshold, because her own advisers are saying that is not what they are about. So no wonder all she has is Sir James's bright lines, some violence here. That is not this case. This case is about damage, serious damage to property. And 3 incidents, and with great respect to the court below, that's all you've got. And as a matter of ordinary analysis, 3 out of 383, they are outliers.
May I just ask you, say 3, the instrument that the Secretary of State ultimately made
Yes.
to prohibit Palestine Action was made after a 4th incident,
Right.
Rise Norton.
I'm going to comment.
And she put that in her statement.
I'm going to...
A, is she allowed to consider it? And B, even if she isn't, is this court doing the
Yes.
proportionality assessment allowed to consider it?
Yes, you are. I can give you the reason if you're interested, but I think, except you are, I'm going to give you submissions on it. I'll make 3 submissions on it. Doesn't advance the analysis. I'll come on to that in due course. At the moment, I'm interested in her decision-making, if that's okay, in what she was looking at in the documents. And I will address you on Bryce Norton.
Well, you can't ignore Bryce Norton.
I'm
in
not
that.
for a second saying
No,
it's
in
what
terms of
prompted
but no, but you were saying you were looking at what she was looking at. And she clearly was
In
looking
these
at
documents.
Bryce Norton.
Right.
She was clearly looking at Bryce Norton when she made the announcement.
There's no assessment of what happened in Bryce Norton.
No, but
There's
she was clearly looking at it,
She was
wasn't
clearly looking at it.
And taking it
You
into
haven't
account.
been- the relevant date for analysis of the Article 1011 issue was late November last year. No evidence about that. 0 about Bryce Norton. Nothing. No submissions from Sir James that fulfills the definition. Nothing. I can give you the references. Nothing in the divisional court. Nothing here. And there are reasons for that. There's evidence about the level of damage. There's evidence about how quickly the planes were flying again. And then there's the history. But please, I don't want to get out of turn. But
No, no.
that's a snapshot.
Good, you're going to come to
3
that.
points.
So at the
about
moment
both.
you're on the 4th of June.
Yes. So I was on the second of my 4 points in respect of this assessment. PA commits or participates. At 4 points, I've just finished my second one. The third point is that of the 3 actions relied upon, the first, Thales, was 25 months before the decision to proscribe, and the last, Filton, Elbit Systems in Bristol, was 9 months before the decision. We respectfully submit that that undermines the assertion made by the Home Secretary on behalf of her that proscription has led to a de-escalation in the seriousness of Palestine Action's activities. That's made in evidence on her behalf. No actions satisfying the definition of serious damage to property for almost 1 year prior to prescription, 3 in the preceding 5. You've got that. And you've seen what I've said about the 158 actions. The Secretary of State says, tell me about post-August, 158, no violence, no Section 1. But I just want to spend a little bit time on the first one of Thales, because that illustrates what we submit, with respect, is a rather shifting assessment of the relevance of that incident. Prior to the March assessment, the Thales incident had not been assessed to constitute an act of terrorism. That wasn't an oversight. It had positively not been assessed to amount to an act of terrorism. And we have a number of dates, we have 2 dates that are interesting before and a date that's interesting afterwards. The first date that's interesting before is 19th of April, 2023. I'm sorry, I hope it seems to me to be important to spend some time on this. 19th of April 2023, this is a meeting between the policing minister, Chris Philp, and the CEO of Elbit Systems. It's 9 months after Thales. The reference is Supplementary Bundle 1, tab 6C, hard page 90, soft 99. Please go to, and this is a document that my client obtained under the Freedom of Information Act. Please go to page 92. Sorry, 90, first look at 91 in the hard, 100 in soft, and 101. So do you see, second paragraph, although they've been successful, there have been successful prosecutions of Palestine Action members, multiple instances of charges being dropped, defendants acquitted, and then across the page, the next page, the final paragraph before the redactions, Palestine Action does not meet the threshold for prescription as they do not commit, participate in, prepare for, promote, encourage, or otherwise be concerned with acts of terrorism. Now, that remained the view of the government's independent advisor on political violence and disruption, Lord Walney, as of May.
Sorry, you said this was a meeting just...
Right. Okay, it's explained, sorry, I should have given you the number. It's explained in Ammori 2, which is at tab 6, and it's pages 61 to 62, hard, soft, pages 70 to 71. It's explained at paragraph 35 to 36. You see that, my lady?
I'll read it.
Yeah.
Paras 35 to 36.
Yes. Oh, yes. She basically explains what that is, what that exhibit is. Yeah. It's a minute of a meeting between Chris Philp and the CEO.
It's not Chris Philp, that's the point.
I got that wrong.
Yes.
Chris Noble, I'm so sorry. Oh, no, it is Chris Philp. Sorry. Paragraph 35, it is. Paragraph 35, Policing Minister Chris Philp.
It's just attendees on page 90 are different.
Yes, I'm very grateful. The document is a briefing note that was handed over at that meeting. The meeting eventually occurred on the 19th of April. The briefing note predates that by a couple of weeks. I'm told that's correct by my learned junior Miss Burke.
This handed over to Mr. Well, to the gentleman from Elbit
Is it Mr. Fawcett, is it?
Yeah, okay.
I think it's, is it? I can't remember. Yes, it's the CEO of Elbit. Now, that assessment remains the view of the government, of the independent advisor anyway, Lord Walney, as of May 2024. And that's quoted, I'm sorry we haven't got that, but it's quoted in our amended statement of facts and grounds. Core bundle, tab 20, page 1561, paragraph 20, Roman 2. What?
Sorry,
Page 156I. Ah, yes, sorry. I mistook my I for a 1. It's page 156I. And then, after the March assessments, we see that as far as the Scottish authorities were concerned, this incident having taken place in Glasgow, they did not think this constituted an act of terrorism. And we have that from the Scottish Contest Review Board meeting. This is May 2025. May I please just give you the reference rather than taking it up? It's Supplementary Bundle 2, tab 36A, page 705, hard, 717, soft, and obviously this is well after Thales, almost 3 years after Thales, and it's put pretty emphatically. They say, currently within Scotland, this group has been focused on protest activity which has not been close to meeting the statutory definition of terrorism, despite, in the paragraph above, the Contest Review Board saying Palestine Action has been, quote, extremely active in Scotland, President Trump's golf course and so forth. Not come close to meeting the statutory definition. And then there are points about value of damage. They were overstated. Just give you one reference. Dewar 1, Craig Dewar 1, paragraph 5, supplementary bundle 2, tab 32, page 665 hard, 677 electronic. That's the third of my 4 points. My last point is that, if anything, the evidence before the Home Secretary was of a de-escalation in Palestine Action's activities in the 9 months prior to proscription, i.e. following Elbit Systems in Bristol, August 24. And it's, I'm not going to turn it up, it's those two NOPC, National Police Coordination Council documents, September and December. In September, they say, since the action on the 5th of August, there's been a reduction in direct action with the focus on solidarity for those arrested. That is tab 18, page 241, hard, 250, soft. And the December document, which says a similar thing, is at tab 21, page 268, hard, top of the page. And that's 277, top of the page, soft. And at 270, hard, 279, soft, 2/3 of the way down the page. And what is said is the number of actions has reduced in December. Despite a reduction in their direct action, they've remained active. Bryce Norton, I said 3 points. Secretary of State's case before the Divisional Court was not that the Bryce Norton incident amounted to an act of terrorism. See Secretary of State's Divisional Court skeleton, paragraph 59. It relies on the same 3 acts I've addressed above. Core bundle, tab 27, page 278. It's the same in soft, I think.
Just wait a minute, please. Thank you. So, page 278,
Oh, it's in soft.
fair balance.
Sorry, my lady? Yes, sorry. Yes, it's in soft, it's 432, hard 278, and the relevant paragraph is paragraph 49. It's not that Bryce Norton amounts to an act of terrorism. That's not her case then. It's not her case now. First point. What? It's 59. Did I say something else?
Yes, ma'am.
Paragraph 59. I'm
Yes,
so
thank you.
sorry. That's
No,
why.
I think you said 59. Yes?
The second point is, please look at, in due course, at Mr. John McAvoy's third statement, he's a journalist, paragraph 7 of his statement, supplementary bundle 2, it's the third hard bundle, tab 45, page 800 hard, 815 soft, paragraph 7, the two planes that were the subject of damage returned to operation within days. And then the third point on Bryce Norton is not surprising that Sir James does not make a claim that this amounted to Section 1 conduct, because at least historically, it may be that the past is a different country where they do things differently. At least historically, this sort of direct action criminal damage at military bases has not been regarded as terroristic. See, for example, the Jones facts. Jones is famous for Lord Hoffman's quotation at paragraph 89. I gave you references to the facts of the Fairford appellants and the Marchwood appellants in Lord Bingham's speech at paragraphs 4 and paragraph 7 from memory. That's Bryce Norton. Okay,
Sorry,
so the
it's
next...
my fault. I missed the third point. The first one was not Secretary of State's case.
Not case. Secondly, McAvoy.
And
the
third?
third is look at history. Historically, this sort of direct action criminal damage at military bases has historically not been regarded as terroristic, so no surprise. It's not here. See the facts of Jones. The facts of Jones. Para 4, Lord Bingham. Para 7, Lord Bingham. Okay, so those are my points on the first link, commits or participates in. Second link, concerned in terrorism, is because it promotes or encourages terrorism. So the Secretary of State says. JTAC assessment, please. Tab 10A, paragraphs 33 to 36, and 35 in particular, pages 164 to 5, electronic 173 to 4. So what is said? It's said the group presents the Filton 18 as political prisoners and has shared statements from Amnesty International and the UN which express concern regarding the use of tact legislation to detain 10 members during initial arrests, and it encourages messages of support. That's what you've got on that link. Our submission is that to suggest that sharing statements from Amnesty and the UN amounts to, quote, it's a very serious point, amounts to promoting or encouraging terrorism, does not indicate a serious or credible approach to the statutory criteria. You can just ignore that. It's ridiculous. The third point is that Palestine Action prepares for terrorism.
Just let me have a look at that, given the way you put it, Mr. Hussain. Right. Where are we? Paragraph
35.
34.
35.
35, thank you. Just give me a moment, please.
Of course.
Is that relevant for us or not?
We say what's centrally said there is UN and Amnesty International. They would say the same thing about the property damage in support of their political cause in Kent and Glasgow.
Hold on. So it takes us back to paragraph 20. see. Yep, okay.
Yes, they describe the incidents. So, my lady, I was going to move on to my third point, which is prepares for terrorism. And if you're in that bundle, it's at page 163 hard, 172 electronic. And that prepares, test 2 prepares for, is premised on training and workshops for activists, and in particular the manual. So at last we come to the manual. And that was also relied upon the divisional court, by the divisional court at judgment 24 to 25. Our submission, it doesn't bear the weight which the Secretary of State seeks to place on it. And we have 6 points, very short points. 1, the most significant point perhaps, is that counter-terrorism policing's own assessment was that the mere possession of this manual was unlikely, quote unquote, unlikely to warrant prosecution under section 58 of the Act, i.e. possessing a thing likely to be useful to a person preparing an act of terrorism. And you have that in tab 20 in this bundle, page 264 hard, page 273 soft. And it's in the middle of the page. Palestine Action Underground Manual on its own is an indication of mindset that mere possession with no further evidence or aggravating features is unlikely to warrant prosecution under that section. The section which is about possessing a thing likely to be useful to a person preparing an act of terrorism. Second point we make is, as CTP said on the immediately preceding stage, is that the manual provided little more than basic ideas around operational security. It's an informal, we say, informal document, slightly tongue-in-cheek if you read it. And this is a report on the 19th of December 2024, 4 months post-Elbit, 6 months post-Instra Precision. Third point, this manual was publicly available. That's Ammori 4, Supplementary Bundle 1, Hard 119, Soft 128, Paragraph 6. Fourth point, did it encourage lots of Section 1 conduct? Well, no. If you look at it, we can see what happened. It was published in August 23, so after Thales, and there are 2 incidents in over 2 years. So you talk about hundreds of incidents, because we know there were 158 incidents from August 24 to June 25. You need to go a year back. There would have been hundreds, maybe a couple of hundred. Let's say there was not a single incident then. Still 158 incidents. Nothing after it was published, apart from 2 in over 2 years. And you'll have seen in terms of the action that it recommends, it's not just Section 1 action, it's also spray painting and so forth. Fifth point I want to make is that there's nothing sinister, we say, in the reference to cells. My client, Ammori 4, Supplementary 1, a Hard 120, Soft 129, Paragraph 10. She addresses cells. They're just groups of autonomous people. Autonomous groups of people, sorry. Sixth point, there was evidence before the court that similar manuals by other protest groups have never previously been deemed to amount to preparing for acts of terrorism. The example given is an example from the anti-GM crops movement, and that's Professor Mead, para 23, supplementary bundle 2, tab 28, 629 hard, 641 soft. So those are my submissions
Thank you very much.
on the incidents that the Secretary of State looked at and the three bases on which she decided
Very good,
it was concerning terrorism. National security, I have 4 points.
Difference, yeah.
No, on the facts.
Oh.
4 points. And the first point, 11th of March 2020, obviously limited what I know in open. You'll look at that perhaps on Thursday. 11th of March, FCDO assessment, no significant foreign policy factors. You'll see why I say this in a second. No foreign policy. That supplementary 1, tab 10D, page 183 hard, 192 soft. Second point, 13th of March, 2 days later, the record of the PRG meeting. The PRG, and this is tab 10D, page 214 hard, 223 soft. The record of the PRG meeting, they discussed the impact Palestine Action's activity on wider UK defence equities, including on UK efforts to support Ukraine. 2 days previously, FCDO had said no foreign policy implications. Third point, 18th of March 2023, note of a discussion between the MOD, the Home Office...
23.
Sorry, 25, I'm going mad, sorry. 18th of March 2025, note of a discussion between the MOD, Home Office and police. Please just turn it up if I may ask you to do that. Tab 23 in the bundle, page 305 hard, and it's page 314 soft.
Three.
It starts at 304 hard,
Yep.
which is 313 soft. And I want you to please look at the next page.
Yes.
You have that. So the first question is, the question Home Office would like to understand is, what do Elbit Systems UK and other sites regularly targeted produce, and what do they not produce, and for whom? We don't need lots of detail, but more interesting, what's the first bullet? Overall impact on defence industry is low by proportion. Impact on individual companies has been large. Fourth bullet, there may be an impact on UK defence industry as a whole, including deterring foreign investment, inhibiting UK ability to supply partners in a live conflict. You've got the FCDO assessment a week previously, and in this document, they're actually asking, top of the page, what is it that Elbit Systems do and for whom? And then the fourth point is the Min Sub, 26th of March, and this is tab 10, paragraph 26, page 148, hard, 157, soft. PRG noted the impact of PAG's activity on individuals, organisations and the UK government's strategic defence aims. So they just note the impact. And then on the issue of communication, narrative, they come back to that at paragraph 42B, hard page 151, soft page 160. How to communicate the decision. Min Sub states that communication should articulate the knock-on impact of the UK's defence industry and strategic defence goals. That's what we've got in open. That's it. That's it. The justification for what we say is a colossal impact on individuals, a colossal impact on rights valued not only by the Convention, but deeply valued by the common law. You'll be aware of the Derbyshire Sunday Times decision, famous decision where Sunday Times seeks, the council seek to sue the Times in libel. The House of Lords say political speech, free speech, no availability of the tort at all. It's not a defence, it's just not available. Free speech conditions the law at common law. That's how important it is. Massive impact, and this is what you've got by way of justification. And racism, anti-Semitism, targeting of Jewish businesses. I gave you two references to Mr. Andrew Feinstein, son of a Holocaust survivor, twice ex-MP under President Mandela in South Africa. He said, nonsense, it's bad reporting. They were targeting a landlord of Elbit Systems. He says, I would never be part of a group, given my history, that was anti-Semitic. I gave you a reference to my client refuting that. The JTAC appeared to accept it. JTAC appeared, they say on their website, they say it's effectively an anti-racist organisation. Paragraph 5 of JTAC, page of that bundle, page 160, soft page 169. Racism, sexual abuse, etc., will not be tolerated. Deference, I'm not going to say anything about. I'm just going to say the points are in our skeleton at 70 to 71, 58 to 59, 69.4 to 69.6. You've got all the points, I think.
Sorry, just going back to your reference to 160, are you
Sorry.
saying that the...
My reference to?
No. Are you saying that JTAC got it wrong when they... Did they say that...
No.
Palestine Action, they didn't?
It's never... sorry, I did it very unclearly.
No, that's fine.
For understandable reasons, Sir James opens with this idea of hate crimes and so forth. It's not their case. It's not a case like Farrakhan, for example.
Fine,
Mr.
okay.
Farrakhan, who's excluded from the UK.
That was my understanding, that's fine. Just wanted
No
to make
community
sure I
relations
correctly
issue.
understood you. Thank you.
Right. So deference.
Yep.
Please just look at our skeleton, paragraph 70 to 71, 58 to 59, 69.4 to 69.6. You've got that. That's all. On the issue's impact, they haven't got institutional expertise or responsibility. Impact, you've got much more material than they have. Deference that would ordinarily be due in this context, massively attenuated. I'm not going to say anything else. I'm well familiar with it. So that is ground 2.
Good.
I'm going to, instead of doing ground, can I call it ground 3, which is procedural fairness, our first ground on ground appeal, on cross appeal. Can I please go to discrimination?
Right.
Because it's also Article 10, Article 14. So this is our the second ground we raise in our cross appeal.
Yep,
Rolled up. I appreciate I haven't got permission.
understand.
Division, the court deal with it in fairly, if I may say so, laconic terms at judgment 143 to 145. We don't accept that the challenge wasn't fully developed. It was significantly developed, both in writing and orally. We see that from the transcript. I know you haven't got that.
No, we haven't.
But our skeleton...
What does the transcript show?
Yes,
That it was
I dressed them on it at length. I'm reminded. I'm reminded, but I'm told. I was there, I promise you. But yes. No, I remember citing the extract from Lord Bingham in Belmarsh about under-exclusivity and so forth.
Right.
But it was at length, and it was. You won't find it in our main skeleton below. And the reason for that was that about a week before the hearing, Secretary of State tried to argue that we didn't have scope, we didn't have permission.
Right.
And Mr. Justice Chamberlain rejected that contention. Secretary of State then said, it was the Thursday before, the Secretary of State then said, well, I haven't put in evidence. So Mr. Justice Chamberlain said, well, you can put in evidence and you can seek permission to put in evidence and put in the evidence on the Monday. The first day of the hearing was the Tuesday. or Wednesday. But on the Monday, they turned up with nothing. They took a decision. They had permission to seek to rely on evidence on this point. They didn't provide any. So therefore, sorry, that's a very long way around saying that our submissions on discrimination were contained in our CMC skeleton prepared for that hearing. And that is Supplementary 1, tab 25, hard 347, soft 346. Below, I mean, you don't need to look at that, but it was there. 356, soft 356. Before you, more pertinently, you have our submissions. I don't know if you've got the cross-appeal documents separate or whether you, in the ancillary bundle.
I've got, anyway, we'll find it. You want us to look at your skeleton?
I'm just going to give you a reference. I'm going to make 2 points on legal principles.
Skeleton of the 20th of March 2026.
Yes.
Replacement application for permission to cross appeal.
Yes,
Right.
Yes.
exactly. And also we address it in the reply as well.
Yeah.
And in the first document, it's paragraphs 22 to 38. And in the second document, our reply, it's 10 to 17. Legal principles, just very quickly, 2 points, please. You're not engaged, you're not required to identify a perfect comparator. That's obviously well known. Lady Hale in AL Serbia. Please, can I just give you the references? Paragraphs 24 to 25. Authorities, bundle 1, tab 19, page 561. Strasbourg doesn't place any emphasis on the identification of an exact comparator. They ask whether otherwise similar situations justify differential treatment. The comparability test is glossed over. Emphasis is almost completely on the justification test. You said a similar thing, my lady, do you remember in the AB case? And that's the authorities tab 2, authority volume 2, tab 36, page 1302 at 42, para 42, where you said it will usually be convenient to arrive at the question of justification by the shortest route. You reviewed, I think it was from memory, it was Lord Nichols in one of the early cases, but may have been Carson, a few other.
Right, well, anyway, it's of a
But
piece.
that's
yes.
what you did. Anyway, so get to justification. Don't bother too much about similarity, and you certainly don't look at exact comparator. Otherwise, no discriminate level of conception that can never arise if you're looking for an exact comparator. Second point: what falls to be? And this is very important. What falls to be justified in respect of an allegation of direct discrimination is the difference in treatment. It's the difference in treatment and not the measure itself. The authority for that is the VAT private schools case at first instance, not the case that my lord heard, in ALR, and that is Authorities Volume 2, tab 48, page 1732, at paragraphs 128 to 129. In a direct discrimination case, it was the differential treatment that had to be justified, whereas in an indirect discrimination case, the measure was ex hypothesi neutral. What had to be justified was the measure itself. They carve out something in Philomenos. We don't need to get into that. But that's a very, very important point. It was perhaps most starkly illustrated by Mr. Rabinder Singh's submissions, as he then was, in the Belmarsh case in July 2002, so James may remember, where he articulated the point that what had to be justified was why you weren't interning British nationals who posed the same terroristic threat as foreign nationals did. Classic vice of under-inclusivity. Why are you picking and choosing on a sector on people who may be politically underrepresented and, relatively speaking, disenfranchised. Very, very important point. You look at the difference in treatment. Why us? Why not them? And not the measure. It's terrorism. So everything's fine. Very important point. We make 7 points, please. Would you like me to? Would you like me to?
Are you okay to carry on a bit? Let's try and finish this. 7 points.
7 points. Thank you very much, my lady. 7 points. One, the Home Secretary's own officials contemporaneously recognised that Palestine Action was similarly situated to other direct action groups employing similar tactics. And it's the CIA assessment in tab 10E, pages 191, and then the key pages are 197 to 198, 206 to 207 electronic, that I want to take you to at, page 191 hard, 200 soft. Okay, so national overview, do you have that? Near the top of the page, national overview. HSAI notes that PAG are unlikely to be as well known as other single issue groups employing similar direct action tactics. Similar direct action tactics, such as Just Appellant XR, are likely to be as well known. And then at page 197, hard 206, electronic.
Sorry, the first page was it 219?
Under 3, oh yes, all teams assess it is highly likely. Do you have that? It's in bold. Yeah. All teams assess it's very likely that a prescription of Palestine Action will raise questions about prescribing other organisations, including single-issue direct action groups, pro-Palestinian activist groups, and pro-Jewish, pro-Israeli groups with conflicting objectives. The prescription of Palestine Action would likely bring immediate scrutiny to far less environmental anarchist protest groups, particularly XR, JSO, both of which receive significant attention in Lord Wolney, and, said again, regularly employ direct action tactics similar to those for which Palestine Action has been brought to prescription consideration. And then the assertion, rather blithe assertion, back in the document at 193 hard 202 soft, at the end of the page, NCCT, do you have it? Asserts that a prescription would likely be viewed positively by the majority of UK communities, instilling confidence that prescription legislation, you've got a whole missing page, is being applied consistently across all groups, regardless of ideology, and reducing the ability of a group to garner support within the UK. An extraordinarily blithe assertion, given what I've already shown you. The court failed to acknowledge, let alone address, this evidence. It was absolutely put to them. Second point. Home Secretary now seeks to disavow her contemporaneous acknowledgement of similarity by contending in her skeleton, supplementary skeleton at 23, that this was no more than a recognition of similarities that may have existed between some of the tactics used by Palestine Action and other single-issue groups. But it is those very tactics, that is to say, Palestine Action's commission of serious property damage in pursuit of ideological objectives, which provided the basis for prescription. That was the point made by the Home Secretary's own officials when referring to organisations that regularly employ direct action tactics similar to those for which PA has been brought forward for prescription consideration. So that's not an offhand comment that those groups employed similar tactics with no bearing on the question of prescription. It was a recognition of similarity for the purpose of prescription. Third point, it is no answer, contra court below at 144 with respect, no answer to the allegation of similarity to say that there was no assessment before the court that those other groups met the concerned in terrorism threshold. Firstly, they appeared to accept they did employ similar tactics, but assume that against us. The fact that there wasn't an assessment is evidence of discrimination, not an answer to it. The Home Secretary can't pray and aid the very discrimination that's being alleged. They're prima facie similar, prima facie employ similar tactics for the purposes of prescription, but hey, there's no actual assessment. Well, that's not an answer. It would be a very bad day for the discipline of equality law if that was allowed to pass muster in a context as anxious as this. Fourth point, there was extensive, objective, uncontested evidence before the court. Even if all of that's not enough, the own assessment isn't enough. Extensive, uncontested evidence which indicated that other groups, both contemporaneous and historic, had carried out similar actions, caused similarly serious property damage in the course of their protest campaigns, who had never been proscribed. And I'll just give you the references, if I may. It's Professor Mead, Supplementary Bundle 2, tab 28, page 623. That's hard. Electronic is 635. And please just cast your eye in due course. I don't have time to do it now. Paragraphs 4, paragraphs 5, XR and JSO, paragraph 6, financial institutions, paragraph 7, JSO and XR, government buildings, and so forth. Professor Rogers, Supplementary 2, tab 29, hard 633, electronic 645, and then Mr. Deshmukh 2, he's the CEO of Amnesty, I've already referred to him. Supplementary 2, is it actually supplementary? No, it's supplementary 2, hard copy, supplementary 3, tab 56, page 1024, hard, 1039, soft. Paragraphs 12 to 13, Animal Liberation Front, property damage, letter bombs, incendiary devices, harassment, intimidation. Paragraphs 14 to 15, munitions, Trident plowshares, that's the Jones case. Paragraph 16, climate change, XR, JSO, insulate Britain. Paragraph 17, this is what I referred to as the punchline yesterday. The forms of activism that PA have been engaged in are not new, are equivalent to, in some respects, lesser in terms of severity than forms of activism haven't been treated as terrorist. The court below, with great respect to them, failed to address this evidence in any way whatsoever. It's just simply wrong, perverse, with great respect, to say there was no evidence of conduct capable of satisfying the serious property damage definition as regards those groups. Fifth point, no attempt whatsoever by the Secretary of State to justify the difference in treatment, whether contemporaneously or in evidence. The closest thing that we get is that blithe assertion I took you to. It's really not good enough and quite concerning.
Right.
No, we submit. No attempt at justification in the evidence. We go back to Mr. Justice Chamberlain the week before the hearing. It's not in scope of your permission decision. Yes, it is. We haven't provided evidence. Okay, well, you can try to do that. Do it. You've got permission to apply it to me to put in evidence on the Monday. Nothing. And you see that in the order of the 21st of November. That was when it was sealed. The hearing was the previous day. That was the Thursday. Supplementary 1, tab 26, hard 353, soft 362, paragraph 2. She could have put in evidence. She had permission to try to put in evidence. She chose not to. The sixth point, the court below at 144 is wrong, we say. In fact, profoundly wrong with great respect, to say that the Home Secretary was entitled to consider the case for proscription on its own merits. With respect, that contention completely misses, is profoundly antithetical to the very foundations of equality law. And I just want to take you to one passage in Belmarsh, please, and this is in Authorities, Volume 1.
So paragraph 144 of the Divisional Court's decision is profoundly wrong.
Because they said that the Home Secretary can consider the case for prescription on its own terms. Presumably that means you don't have to worry about comparing. You just look at whether they fulfil the definition, it's proportionate. That's Article 10 and 11.
Right.
What about 14?
Okay, so, and then you want to take us to...
To Belmarsh, which is tab 16 of Authorities 1, and it's Lord Bingham endorsing at page 414, it's at letter H, Article 14, paragraph 46 of Lord Bingham, well-established obligation of the state not to discriminate, etc. And then over the page, so this is page 415, Professor Hirsch Lauterbach, the claim to equality is in a substantial sense the most fundamental of the rights of man. And then Mr. Justice Jackson in Railways Express, and he says towards the bottom of that quotation, the second half, there is no more effective practical guarantee against arbitrary and unreasonable government than to require that the principles of law which officials would impose upon a minority must be imposed generally. Conversely, nothing opens the door to arbitrary action so effectively as to allow those officials to pick and choose only a few to whom they will apply legislation, and thus to escape the political retribution. Remember, they're less well known at the beginning of that document. They're less well known, to escape the political retribution that might be visited upon them if larger numbers were affected. Courts can take no better measure to assure that laws will be just than to require that laws will be equal in operation. Quite so. Why was it that Palestine Action was chosen, out of other groups whom the Secretary of State herself accepted employ similar tactics?
Right, and your final point?
Final point,
In your
sorry.
final minute, Mr.
Final
Hussain.
point, sorry, and thank you so much.
No, we've done very well, and we, I think, are now in parity in terms of time
You're
and
very
on
kind.
track for a 2:30 handover.
Her submission, the Secretary of State's submission in her skeleton, that prescription decisions turn on a broad-based, multifaceted, nuanced assessment which considers a consideration of discretionary factors. With respect, there's nothing in that point. Many decisions involve that sort of assessment. That doesn't place those decisions beyond the reach of equality law. The logical consequence of the submission is that you could never have an equality assessment of a prescription decision. And that can't be wrong. That can't be used escape the fact, in any event, that no assessment whatsoever was conducted. Those are my submissions.
Well
Thank you
done,
very
well
much.
done, Mr. Hussain. You've made good progress. So we just have duty to consult.
That's right.
Left, and then we'll be back with Sir James.
Sir James, yeah.
Thank you all. I suspect you all want a break, but I would like to make sure that we are on track to do something about reporting restrictions at the end of the day. Is that going to be the case? All right, all right. Thank you all very much. 2 o'clock.